and welcome. Good morning, everyone, and welcome to today's Coffee and Consulting session. My name is Frederike Ruch, and over the next 30 minutes, I'd like to take you inside the DACH region. That is Germany, Austria, and Switzerland. And I would like to explore with you the opportunities and the very real compliance challenges that come with cross-border employment across these three countries. Whether you are an HR professional, a manager overseeing international assignments, or an employee working across borders yourself, the DACH region is both an exciting opportunity as well as a regulatory maze, and I'm quite sure you have realized that as well. We'll look at the legal frameworks in the next 30 minutes, social security rules, tax implications, as well as practical steps and how to stay compliant. And in the end, I will give you a clear, actionable recommendation to that. So let's start with a quick look at the scale of this region. The DACH region is a powerhouse, and let me give you a sense of the scale we are talking about. So Germany is the largest one with 84 million people, a workforce of 46 million, and a GDP of 4.1 trillion euros. If you look at the middle column, that is Austria, which is a bit smaller, but still highly relevant, with 9 million people, a workforce of about 4.5 million, and a GDP of 490 billion euros. And then looking at population size, the smallest one, but despite the population being only 8.8 million, the GDP punches well above its weight with 780 billion Swiss francs and a workforce of 5.1 million. So combined, if you look at all these three countries, the DACH region generates roughly 5.4 trillion euros in GDP and has a total workforce of around 56 million people. Crucially, all the three countries share the same language, German, however, which removes one major barrier to cross-border collaboration, but shared language does not mean shared rules. That's exactly the complexity we need to navigate through, and we will do that in a moment. Cross-border workers in the DACH region is not a niche topic. It's happening at massive scales every single day. If you look at the numbers I brought with you, so Switzerland receives over 360,000 frontier workers who cross the border every day to work in Switzerland. And that is actually one of the highest rates anywhere in Europe. Austria sees approximately 70,000 cross-border commuters entering its territory regularly. And Germany hosts around 230 posted workers per year from other countries. The economic backdrop is intra-DACH trade in goods and services exceeds 300 billion euros annually. So the key corridors about cross-border workers is Basel-Freiburg, which is the largest Swiss cross-border corridor, Bavaria, Salzburg, Tyrol, the Alpine commuter belt, and then the Eastern French like Vienna, Bratislava, Sopron, which is then outside of the region we look today, but Vienna, as part of Austria, still is. So, what are the legal frameworks underpinning all of the movement? And we will look at that now. The major legal frameworks govern cross-border work in the DACH region, and understanding how they interact is essential. So the EU free movement is the baseline for Germany and Austria, whereas one of the, I would say, the most important one is Article 45, which is the right to work anywhere in Europe as well as in the um, economic area, as well as then the from the directive, the residency right. Plus, in combination then with the Social Security regulation, which falls under the EC Regulation 883 2004. For Switzerland, there are a couple of other legal frameworks to be considered. One is the agreement of free movement, and the reason for that is that Switzerland is not an EU member, so that the standard EU rules, which we looked at just above, are not automatically applying. Now, the agreement on free movement, however, is kind of trying to more or less indicate the same rules as the EU free movement agreements. So whenever you have a case or whenever you have a situation, you would need to look for anything in where Switzerland is considered, to look at that separately and make a separate assessment to that. In addition to that, which always need to be considered in those cases, is the Posted Workers Directive, with establishing the same pay for same work principle. And I think that is one of the key elements, as well as indicating that a posting, so an assignment as such, should not be longer than 12 months, and only in exceptional cases, you would be able to extend that for another 6 months. So that is kind of the basis for any cross-border movement. These legal layers interact with each other, and that interaction then creates most of the complexity, which we will then discuss in the next slides. And then we start with the topic of Social Security. Social Security is often where companies get caught out because the rules are less visible than tax, but the consequences of getting it wrong are significant. The fundamental principle is the one country rule. So a worker can only be subject to one member state social security system at any one time. And the A1 certificate is the key document. It proves which country's social security system applies to a worker, and this must and should be obtained before the assignment begins and not after. Keep in mind that you also can request them retroactively, but it depends a bit on the country and the situation. But nevertheless, that is something you always can check out in case you haven't applied for it before the assignment starts. So for workers active in more than one country, if they are working more than 25% of their performed work, for example, in the country of residence, then the Social Security contributions are due in the country of residence. And then, in addition, the teleworking rule, where the threshold follows the 14.9% rule. If someone stays below that, So the social security contributions in the country the employer um, is situated will apply. In case they are above that, the social security in the country of residence will have to be applied to the situation. Self-employed workers face special rules, and the country of residence often takes precedence, but is not always the solution. So in case there is a situation and you do have a self-employed person concerned, then make a separate check on it, because it's also from the angle of whether that individual is really a self-employed person or not, rather actually will be viewed also from a social security point of view as an employee. Closely linked to the social security is the question of taxation, and that's where we turn next. Tax is complex in any cross-border scenario, but the DACH region has several specific provisions worth highlighting. So the core principle is the split between residence country taxation and source country taxation. And the double tax treaty between the relevant countries determine which one will apply. One of the specific rules is the 183 days rule, where we see in practice there are always still questions about it, as well as people are getting confused on it a bit. So short-term assignments may be exempt from the taxation in the country of they perform their work if there are certain conditions met. So fewer than 183 days in the country, no salary paid by the employer in that country they are working, and no costs are recharged to that country. But be careful, there is still the economic employer concept, as well as from the Swiss point of view, the factual employer concept you need to consider. In regard to frontier worker clauses, we do have one with Germany and Switzerland, and there's one with Germany and Austria, but there's not one between Switzerland and Austria. Also, in that regard, you need to consider the permanent establishment risk, which is above all, if people are working then from home, something you need to take care quite seriously, and then really have a good look at it and make a good assessment. In particular, in that regard, it is about if a manager, like one of the C-level or C-suite, with authority to sign contracts, for example, will do that from his residence country, which is not the same one as his employer. Like for cross-border employees, this is a bit of an issue. You need to be careful that the employee is not creating there a permanent establishment. Now let's look at the upside, the real opportunities cross-border DACH employment can unlock. When navigating the complexity, it's worth it because the DACH region offers genuine strategic advantages. So one of it is the access to a 56 million strong talent pool, which can fill gaps in, for example, IT, engineering, and healthcare without then physically relocating the staff. The labor cost arbitrage. Swiss wages are roughly 1.7 times the German wages, while Austrian wages are around 0.85 the German levels. So smart role structuring can reduce costs while maintaining the quality. If we look at market expansions then employ locals with cultural and language proximity to build presence in Austria or Switzerland without immediately setting up a full subsidiary. Talent retention. If you offer employees the flexibility to live in more affordable German or Austrian locations while working for a higher paying Swiss employer. Agile workforce scaling, posting workers are using frontier arrangements is faster than permanent cross-border hiring, ideal for project-based scale-up. And cultural and linguistic synergies, shared language removes communication barriers and accelerates onboarding and collaboration across entities. But these opportunities also come with compliance obligations. So let's look at the main risk areas as well. I want to be direct about the risk levels here. So some of these are rated high for a reason. Administrative burden, for example. So A1 certificates, work permits, posting notifications, payroll calculations. Each country has its own procedures and deadlines. Manual processes break down quickly at scale. Double taxation risk is also marked as high because of incorrect residency or permanent establishment analysis can trigger tax obligations in both countries simultaneously. The double tax treaty disputes can take years to resolve. Also marked as high is the social security complexity. So determining the correct social security state for multi-country workers is not trivial. Errors result in retroactive contributions or may result in retroactive contributions plus also penalties. And the permanent establishment risk is marked high as home office employee or manager with authority to sign contracts or salespeople may inadvertently create a permanent establishment and then triggering unexpected corporate tax in the country of residence. Medium is marked the posted worker rules as well as the Swiss non-EU status. And there you can see for posted worker rules that host country minimum wages and working conditions must be guaranteed with extensive documentation that is actively audited. And if you maybe look at how many labor market controls you had in the previous 12 months, then you also maybe see that that number is increasing year by year. Therefore, it is good to be well documented with that. Let's go one level deeper with a quick country by country comparison. I'll keep it short. So the aim is just to highlight where each country diverges from the others. Germany, basically European, so EU or economic area citizens have immediate right to work. Third country nationals need a residence permit, and the new Skilled Worker Immigration Act has broadened access significantly. The employer social security contributions are around 21%, and the home office rule applies, and there the 24.9 and or 49.9% rule has to be considered. This fact about the home office regulation, you will see on each slide, you will see that also marked at the slide for Austria and Switzerland, because all three are basically have to consider that or are considering it as they have signed the teleworking agreement. Posted workers must be notified via the Zoll portal, and the minimum wage is 12.82 euros. And if you look at the tax rates, then we go up to about 45% plus the solidarity surcharge. So quite a bit. And if you now look then later on at the tax rates from Switzerland, you can definitely see why Germany is one of the high tax countries called. If we look at Austria, then EU and EFTA citizens have in general free access. However, they have to get registered within 3 months. And for non-EU EFTA nationals, they need a red card, which is quota-based, or the EU blue card. Social security contributions are a bit similar as Germany, also about 21% for the employer and 18% for the employee. And if we look at the tax rate, then the income tax reaches about up to 55%. In regards to posted workers, you really have to make sure you notify any person you post to Austria, because they are quite strict on it, and actually are the fines and penalties linked to it are quite heavy. Minimum wage is slightly higher than Germany, which is 13.07 euros. Now, the numbers you see here are 25, because when we were looking for the numbers for 26, we didn't find for each country the same number. Therefore, those are still 25 numbers to compare, but it gives you an idea of where they are. Let's move on to Switzerland. For franchise workers, we need the cross-border permit if they're crossing daily or weekly within the region. And usually EU EFTA nationals have priority when you hire them in comparison to non-EU nationals, because they fall under the work permit quotas if we look at it from an immigration perspective. Social security contributions are slightly lower. However, even they are only around 14% for employer as well as employee. In comparison to the other two countries, Germany and Austria, we don't have a contribution ceilings, at least for the first pillar, for the AHV. Therefore, in the end, if you look at the number, if you look at the final social security contributions, that might end up much higher than the other two countries. Postage workers, we have the also a kind of a postal worker or notification process in place, which basically means equal treatment obligation. So Swiss minimum wages and conditions have to be applied, and you would need to do the notification with an 8-day advance period. From a tax point of view, we do have huge cantonal differences. And for frontier workers, at least from Germany, we do have special provisions. We also have then special provisions for when the frontier worker or cross-border worker is coming from Italy or France, but there's none for the one from Austria. Now, with that keeping in mind, I would like to go quickly through the process from an assignment, and then afterwards finish up with our recommendations as well as the key takeaways, and close it for today. So the assignments in the DACH region, we have looked at a couple of them now before the assignment, and that is not now special to those three countries. you will have to make a full assessment and see what is actually the liabilities as well as the situation from all the legal aspects. Assess the social security competence, obtain the A1 certificate, and also review the applicable double tax treaty so that you can check on that. Check on work permit requirements, and above all, we have seen that each country has minimum wages which need to be considered, so assess them as well and in the host country, so to make sure you have everything in line. During the assignment, you have to submit the posting notification if you are assigning someone to the other country. You will have to consider and monitor the 183-day threshold because looking at the tax rates, you may definitely want to try to use the 183-day rule as best as possible in order to avoid taxation in the other country. Also assess the permanent establishment risk because that is something, especially with home office, worthwhile to look at. And as soon as the employee or assignee is coming back, check on filing the tax returns that has been done during the assignment process, reconcile the Social Security contributions, and claim refunds when overpaid, and make a final review on everything, that everything is done and in line with what you need, as well as what is always worthwhile to do before the assignment start, to make a short cost projection, and then after the assignment to see whether the projected costs have been reached or actually exceeded, and if exceeded, then or check on why it has been exceeded and make sure that in future you have that better in line. Also, keep in mind you need to have those documents ready by hand, as well as maintain records then also for 7 to 10 years, depending a bit on the country, the number of years is different. So what does good look like in practice? Let's see our recommendations to it. We have tried, or I have tried to put down it in 5 points. And these recommendations, I think, are regardless of your company size or the volume of cross-border arrangements you manage. One is to build a cross-border policy, so standardize assignment types, approval workflows, and documentation requirements across all the DACH entities. Ad hoc decisions usually create risk, or a higher risk than actually if you plan for it and have it following a certain process and procedures. Centralize the A1 management as well as the management of posted worker notifications. Designate one HR payroll owner for it so that every person knows exactly who the responsible person is. Also, it might be useful to consider specialized software or tools if you have a very high number of it. Establish a home office permanent establishment protocol, so define clear limits on how many days non-resident employees can work from home in your country, and document the policy, and also, and that is quite important, enforce it. Because it's not only good if you just have everything on a paper, you also need then to make sure it will happen. Conduct annual reviews, and that is not now only for double tax treaty or tax situations, but also from an immigration perspective. So in case there is there are changes, you can actually make sure you have that everything in line. And then keeping in mind that all these three countries are quite different, you and the situations are getting, I think, more complex every year. At least when I look back 15 years or 20 years ago, everything was kind of more simple because there was just long-term assignments and short-term assignments, maybe for 2 years. If I look today, what we deal with on a daily basis, then we rather are with short-term assignments. Long-term assignments are quite rare, as well as everything has to be done or been made within a couple of days. So the timing is one of the key things where it's getting more complex and complicated, as well as that if you have someone assigned from one country to the other country, you maybe have situations where the employee is still residing in one country and not moving with his full family to the other one. So there are different scenarios looking at today. Therefore, it might be worthwhile to look at to whom you actually can work with and engage local advisors whenever you need and when you see that there's something you can't actually deal with on your own. And that will lead me to the last slide for today, where I've tried to put it down a bit the 7 key takeaways for today. Um, and it's also a kind of a summary of everything we've covered. So the DACH region is a huge opportunity, but with real complexity. DACH cross-border work unlocks talent and markets, but each country has distinct rules, and you should never assume what works in Germany that also applies to Switzerland or Austria. Social security determines everything, and for me, actually, it's also the highest risk if you don't get it right. Therefore, always have a key look at the social security situation because that is something where it can cost a lot in case it's got wrong. Keep in mind to request those A1 certificates, and maybe also keep in mind the A1 certificate is also required if you send someone to another country for just one day and for just maybe visiting a fair or conducting a business meeting. That also requires an A1. And maybe one point to that on top of it, it's if you send someone to the other country and you request the A1, you will need to do that for the exact period the person is going to the other country. So if you request an A1 for 12 months because you know the employee is going during the next 12 months a couple of times to, for example, Germany, um, from a Swiss perspective, that is fine and good. The problem is that the German authority actually would like to see for each short period the employee had been going to Germany a separate A1. So maybe in case of a labor market control is coming or anybody checking on it, the authority might, or the German authority might come back and say the A1 certificate you have for 12 months is not okay, it's not valid because of the period is has to cover just this specific period the employee had been in the country. Home office is for cross-border workers of frontier a new risk. So keep in mind and have a real good look at and try to find a policy and establish a process, also a review process where you definitely have a look at every year at least, to make sure that is in line with what you also or in line with the social security rules you apply to the person, as well as the tax rules. Posted worker notifications, keep in mind that you might have huge late filing fees or consequences in case you don't file it in time. In Switzerland, Austria, as well as in Germany, you need to do that before the assignment starts. So make sure you have that ready. Otherwise, that might be a bit costly. Tax challenges are significant as well. There are major differences, and make sure if you would like to actually optimize the situation, you have all the rules in hand and you make sure to follow them as well. And then last point would be just really to try to build processes, not just try to build the knowledge. See where you can actually also make time good in case of making or drafting a cross-border assignment policy. And what I really can recommend you use a specialist in whatever country you need before making your own assumptions. And as much as AI and internet is super and great and you can find lots of information, in the end it's crucial that you have found the information and the answers to your questions for that specific situation you're looking at. And sometimes that can get quite confusing. It's also getting confusing for us, where we deal with that on a daily basis. And we also need to then make sure we do have the right facts ready. So thank you very much for your time today. In case you have any questions to that, then we are happy to answer them. You just can drop us an email and we're happy to provide you with the answer to your question. Before I close for today, I would like to point out our conference. There are still a few places free, which is for 3 days, where we have a fantastic program, fantastic people speaking. The first day is really technical. It's about what we just talked: taxes, social security, labor law, and immigration, covering the DACH region, so Germany, Austria, and Switzerland. And then the other 2 days, we have great companies explaining us and telling us their stories. So I think it is really worthwhile to have a look at it and check it out if you still want to join us. The next seminar we then afterwards have on the 22nd of October. It's about expat payroll, processes, compliance, and best practices. Also, I think something, if you deal with payroll, then worthwhile checking out the program and then joining us. And the next webinar we will have about taxation of international assignments on the 22nd of September, as well as the next Coffee and Consulting is at the 6th of July already, to global compliance challenges. So thank you very much for your attention today. I'm looking forward to see you at one of our other events and wish you a wonderful week. Thank you.